There's three major Supreme Court decisions. Together, they could permanently restructure who holds political power, who legally counts as American, and whether the stranger behind you at Starbucks is carrying a concealed weapon. I'm Brian. This is the Exhaustive Majority. And today, we're examining the legal fine print so you don't have to. Let's get into it. Now, most media coverage focuses on the horse race politics, who's winning, who's losing, the daily news cycle. We're not going to do that today. So the first case we're going to look at is the war on the deep state, Trump v. Slaughter. Now, for nearly a century, the machinery of the federal government has depended on something that most of us have completely taken for granted. Independent agencies. Bodies like the Federal Trade Commission and the Federal Reserve. They were designed by Congress to operate as technocratic shields against political whiplash, protecting your consumer data, your savings, stable interest rates, things like that, from the impulses of whoever happens to be sitting in the Oval Office. Now, this case is a full frontal assault on that entire framework. Now, the administration's argument rests on what legal scholars call the unitary executive theory. And that's an idea that the president has total, unreviewable control over every single person working in the executive branch. Now, to get there, they need to overturn a court decision called Humphrey's Executor. It's a landmark 1935 precedent that protects agency heads from being fired without genuine for-cause reasons like neglect or actual illegal activity. And right now, the president cannot fire the chair of the Federal Reserve because he doesn't like what the interest rates are doing to his poll numbers. If the administration wins this case, any president can do that in the future. Now, think about what that means in concrete terms. The FTC is the agency that stops your internet provider from secretly selling your browser history. The Consumer Finance Protection Bureau, they block predatory payday lending schemes that have targeted working families in the past. Now, the Federal Reserve, now that sets the benchmark interest rate. That ripples through your mortgage, your car loan, or even your small business line of credit. If Trump wins this case, he and future presidents can unilaterally undo these or any other actions by independent agencies simply by firing any agency head who refuses to follow his command. There would be no legislative check on his power, short of impeachment. As we saw in 2021, the politics of an impeachment conviction of the Senate make that almost impossible. Now, these are not abstract bureaucracies. They are the referees of your financial life. If the president can fire any one of them the moment they make a call he doesn't like, that just completely changes the game. So we already got a frightening preview. The administration attempted to remove Federal Reserve Governor Lisa Cook in Trump v. Cook, triggering worldwide alarm from economists and even visible hesitation from some of the most conservative justices on the court. There's a reason for that hesitation, because we've seen this movie before, back in the 1970s. So back then, the Nixon administration pressured the Federal Reserve to cut interest rates heading into his 1972 re-election campaign. He was trying to juice an already strong economy that didn't need the stimulus. So what happened is the economy overheated. And what followed was a full decade of stagflation. And it took the Federal Reserve Chairman Paul Volcker deliberately triggering a painful recession in the early 1980s to finally break the cycle. Now that took extraordinary courage. And it was only possible because Volcker didn't answer to any politician. No elected official would ever risk their career that way. And that's the entire point of independence. So here is the defining legal challenge. Can the court protect the Federal Reserve's unique independence while simultaneously handing the president at-will firing power over the FTC, the SEC, and every other independent agency? Threading that legal theory needle, if it even can be threaded, will be the most consequential legal maneuver in this ruling. So now, if Slaughter redefines the executive's power over people, our next case completely redefines the executive's power over who belongs. That's case number 2. Defining the citizen, Trump v. Barbara. Now, this one is the undisputed blockbuster of the term. The president himself attended oral arguments, a genuine historic first. What's at stake here is Executive Order 14160, which seeks to deny birthright citizenship to children born on U.S. soil if their parents were unauthorized immigrants or were only here on a temporary visa at the time of their birth. This is a direct challenge to the 14th Amendment's Citizenship Clause. It's language that was written after the Civil War specifically to ensure we would never again create a permanent legal underclass of people born on American soil but denied basic human rights. While it's true that the prediction pundits believe this decision will not favor the Trump administration, we need to fully understand what they're attempting to impose. So the court is weighing a radical revisionist theory against 150 years of settled law. So here are the two arguments without partisan spin. So the revisionist view. Citizenship is a social compact requiring mutual consent. The phrase, subject to the jurisdiction thereof, demands full political allegiance. Entering without authorization is an act of defiance, meaning the parents and their newborn child never entered the compact at all. Therefore, they're not eligible to be citizens. Now, here's the originalist view, championed by conservative scholars, including Keith Whittington. Subject to the jurisdiction simply means you're under the authority and protection of U.S. law. If you break the law here, you face our courts and you serve time in our prisons. The only historical exceptions to birthright citizenship were children of invading armies or foreign diplomats with sovereign immunity, who literally cannot be prosecuted under our laws. Unauthorized immigrants have no such immunity. None. Now, let's set aside the legal theory for a second and think about the actual human stakes. Now, imagine a child born in a local suburban hospital, grew up playing in your neighborhood Little League team, attends American public schools, speaks English as their first language, knows no other home. If the revisionist view prevails, hundreds of thousands of those children face permanent legal limbo. Born here, but stateless. Not a citizen anywhere. We're not talking about a minor administrative process. We're talking about enabling mass deportations, mass detention, and family separation on a scale this country has never attempted. No system currently exists to determine a baby's citizenship based on their parents' immigration paperwork at birth. Hospitals, courts, schools, and local governments would be left with no federal guidance and no infrastructure to sort it all out. The impact doesn't stop there, though. It puts voting eligibility of every American in doubt. A birth certificate would no longer be sufficient proof of citizenship all by itself. Adults born to unauthorized immigrants, or even to parents here on temporary visas, could have their citizenship challenged decades later with no system built to handle that. Frankly, I have my own personal experience with this. I had to wait 2 months last year just to renew an expired passport after the federal staffing cuts that gutted the State Department's processing capacity. Now take that headache and multiply it by millions of lifelong Americans suddenly forced to reprove their citizenship that was never up for debate. It would cause a systemic catastrophe we simply don't have the infrastructure to solve. Now, if Barbara redefines who counts as American, our final case redefines the balance between individual rights and private property. Case 3. The vampire rule and gun rights. It's Wohlford v. Lopez. Now, this third case sets up a direct collision between two values most people in the exhaustive majority hold simultaneously: Second Amendment and private property rights. This case challenges what's called the vampire rule, the idea that, like a vampire requiring explicit permission before crossing the threshold, a gun owner must obtain advance permission from a property owner before carrying onto private property open to the public. This isn't an abstract legal concept. These laws currently cover 86 million people across Hawaii, California, New York, New Jersey, and Maryland. Applying the doctrine established in its recent Bruin and Rahimi rulings, the conservative majority signaled deep skepticism during oral arguments back in January. The ruling appears likely to flip the default entirely. Guns automatically permitted everywhere unless the business owner actively posts a sign to bar them. Think about what that actually asks of a local business owner, a restaurant operator in Newark or Honolulu, who doesn't want firearms in her dining room during the Saturday morning rush, now has to make a public political statement just to maintain the baseline she had last week. She may face blowback, social media attacks, or lost customers simply for wanting what businesses in 45 other states already have by default: the right to stay out of the culture war entirely. And look, as a center-left moderate and a supporter of the Second Amendment, I'm honestly not losing much sleep over this specific case. After all, 45 states already operate without this rule. It works fine, without much drama for the most part. But what should concern all of us, left, right, and center, is the underlying pattern of federal court overriding state and local authority historically respected under the 10th Amendment. And that pattern connects all three cases. Let's take a look at the big picture, the Republic reconfigured. When we step back and look at all these three cases together, the big picture becomes very clear. Slaughter expands executive control over the professional civil service. Barbara narrows who legally belongs to the American body politic. Wohlford federalizes the domain states and local communities have long governed. Every arrow points in the same direction: power concentrated upward, away from local communities, away from institutional checks, and toward the presidency with fewer constraints than any in modern American history. The court's liberal justices, Jackson, Sotomayor, and Kagan, aren't just dissenting. They're sounding alarms. They're writing opinions less for today's courtroom and more for tomorrow's history books. They're targeting the court's expanded use of the shadow docket, which lets the administration impose sweeping structural changes through emergency orders without full legal briefings, public scrutiny, or transparent accountability before a single oral argument is even heard. What we're watching is a Roberts Court that occasionally checks the executive branch on a specific policy, like we saw with the tariff disputes, but structurally appears fully prepared to ratify a vastly expanded Article II presidency with less day-to-day accountability than this country has seen in generations. Now that pattern should be alarming, regardless of which party you prefer. The small government conservatives who spent decades warning about federal overreach should find this just as troubling as any progressive critic. The irony that those traditional roles have essentially reversed is not lost on me. But the executive majority didn't get here by giving up, and we're not starting now. So, right now, roughly 58% of Americans disapprove of where this country's political leadership is headed. Whether you're center-left, center-right, or just someone exhausted by a system designed to make reasonable people give up, it is tempting to look at all of this and just throw your hands up. Don't. That's exactly what the partisan fringes are counting on. These decisions will reshape our civil service, our definition of citizenship, and our public spaces. When you walk into the voting booth, your choice cannot be about screaming headlines or culture war theater. It has to be about electing people who genuinely respect institutional guardrails, long-term stability, and the foundational principle that no single branch of government should concentrate this much authority without constitutional checks or public accountability. It doesn't matter if it's left or right. Those are the things we need to focus on. We're not the alternative. We are the exhausted majority, and we hold the majority power. We just have to unify from the center left and the center right and to everyone in between, and stand up and exercise our power at the ballot box. And we are the ones that need to fit the puzzle pieces of this country back together again when the extremes are tearing it apart. If these rulings have you wondering how we fix a system that keeps producing them, click right there above my shoulder where I look at the gerrymandering crisis from both sides and lay out the reform ideas that could actually make Congress represent people like you and me. Congress is where this fight ultimately has to be won after all. So which of these decisions worries you the most? Drop in the comments. I read and respond. If this kind of commentary, the kind that examines the legal fine print instead of echoing the loudest pundits, is useful to you, please gently tap that like button, subscribe and share. Stay sane, keep them honest, and never lose hope.